J&K didn't sign a standstill. The records show there was some toing and froing and eventually, which means he retained all his power. So as far as internal sovereignty is concerned, the standstill was very important because all the powers of the Maharajas and the coming states, my lord, retained their internal sovereignty. Now come to the merger agreement. The merger agreement is important, my lord, because it finally indicates the extent of internal sovereignty. If there was no standstill agreement, and if there was no merger agreement, my lord, the Maharaja would be absolute, as Premnath Kaul says. So I take 370 to be, my lord, a substitute, a constitutional substitute for a standstill and merger agreement, without which, my lord, we are lost. And I'll explore that, my lord, later when I come to 370. Your lordship also, my lord, put a question to Mr. Zafar Shah that on the 4th of August, what were the autonomies that you were going to lose? He promised you a list, my lord. One answer to that is everything, but I will indicate what these autonomies meant and what was lost for Jammu and Kashmir, which comes back to Justice Kaul's question, are we flogging a dead horse? The answer is no, my lord. It continues, and it has to continue to preserve, my lord, the federation and the conditions under which the federation was created. So let me begin with what I began with the other day, my lord, and that is that we have the greatest diversity in the world. Take many continents together, take many countries. This diversity is unparalleled. That is why, my lord, Professor Ravinder Kumar, I asked him, I said, what should I say in my Colombo lecture? He said, say that the Constitution of India is a constitution for a civilization with many nations and many cultures. And this is what makes our constitution more exciting than any other. On the question of diversity, I was taking your lordships to, where is my other note? Just reading it. I've, my lord, done a list which I'll give to your lordships, my lord, but I was going to invite your lordship's attention to Article 3 first. All of Article 3, my lord. But I'm going to read one important aspect of it, my lord. And that is the proviso which says that before anything is done under Article 3, it is mandatory for the President to refer the bill to the legislature. Mandatory. It's a condition precedent before you invoke Article 3. Just as there are conditions in Article 370 which have to be fulfilled by condition precedents. Now on Article 3, my lord, the proclamation of 19th December virtually created an amendment of Article 3 by taking the condition precedent out. Mr. Sibal read all that to you, but I want to refer your lordships, my lord, to that particular part of the proclamation. My copy, somewhere here. Your lordships will find this, my lord, Like Mr. Dwivedi, I have no problem with what your Lordship is doing. We just have to learn and catch up, my Lord. This your Lordships will find in volume 3 documents.
Page 92.
And the PDF, my Lord, I'll just give it to your Lordships.
Page 92.
PDF 92. Now, my Lords, I want to take your Lordship straight away, and it's very important that we should.
Sanjay Miller. Ultimately, everything boils down to this. Of course, the Constitution itself, and but so far as documents are concerned, in one page now we have. In case something is missed, you can tell Mr. Dr. Dhawan's instructing advocate. They'll just put it in and read. What do we call this? This plastic made up.
Divine fire. Your Lordship will see that there is a condition precedent in Article 3. And this condition precedent, my Lord, was added to by CO 48, which I'll show to your Lordships in a moment, my Lord, which further required the bill to be sent to the legislature of the state, but we're not concerned with that because it has to be sent to every single state. Now, my Lord, I take your Lordships to this notification, C subclause 2. So much of the first proviso of Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that article, so that much of clause 2 of 151, which is about audits, my Lord, of the Constitution as relates to laying before the legislature of the state of the report submitted by the Governor to the Controller Auditor General. You will see that the opening sentence is, the following provisions are suspended. In other words, my Lord, a mandatory provision of Article 3, whether it applies to Kashmir or elsewhere, my Lord, is suspended. It's not a question of just laying before Parliament as a substitute. Article 3 and Article 370 does not tolerate substitutes. Now, my Lord, what does this do? This is not, my Lord, that can be done under a proclamation under 356. It is a constitutional amendment which is subversive of the Constitution itself. If this suspension fails, my Lord, President's rule will fail. And its extension, my Lord, in July will also fail. You have amended the Constitution, albeit to all states and certainly to Jammu and Kashmir. And this mandatory provision takes us to the core of the mandatory requirements, my Lord, of Article 3. Because the entire JK or Reorganization Act emanates from Article 3 and Article 4. Take away this condition, my Lord.
How do we deal with this Article 356(1)(c)?
Sorry, my Lord.
Article 356(1)(c) says that if he may make a proclamation where a situation has arisen that the government cannot be carried on in accordance with the provisions of this Constitution in any state, and then C.
Make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this Constitution relating to any body